This is a special report from True Crime Today and the Hidden Killers podcast.
Bryan Kohberger back in court for another rather large motions hearing. Let's take you to the courtroom right now.
See, frankly, the concern with respect to the use of a model in a case like this. So I'm going to allow it. The state will make it available to the defense prior to the pretrial conference and sooner if it doesn't sound like it's complete yet, but as soon as it's done and certainly as quickly as possible. And like I say, it's not going to be allowed for evidentiary value. It will be a part of the testimony. Whoever testifies is going to have to testify that it helps explain their testimony and that it's consistent with their observations. That's subject to cross-examination by counsel. If there are problems with the model in terms of view lines and things of that nature that they were able to put together through their own visits, through their own studies, through their own opportunities, including through their experts if they want to. So. All right, next I have self-authentication of records and reliance on 803. I'm not sure we're ready to argue this because I don't think the state has complied with the obligations in order to rely on the self-authentication issue if they haven't provided the specific documents and certificates that they're intending to rely upon in advance of the motion at this point. So I'm not sure that this isn't premature.
Yeah, Your Honor, we agree. That's probably an accurate statement. And a better time will be after the exhibit witness list is due, and then the parties have to get together and determine what exhibits we have objections to, and then we can address this issue.
Part of my scheduling order is a meet and confer over the exhibit lists to determine whether there's a good faith basis for an authenticity objection or not. And certainly the rules on self-authentication are crystal clear as to what is allowed. And so if it meets those, then I imagine we won't have a problem. Want to add anything, counsel?
No, Your Honor, I won't right now.
All right, let's talk about alibis. This is the state's motion in limine.
Thank you, Your Honor. Excuse me. First off, I want just for the record to make a record of the corrections to the typos that I missed in our initial filing. I emailed Your Honor's staff attorney and counsel over the weekend. There were dates that were wrong. Page 1, item number 2 of our motion. It should be July 27th instead of July 22nd on that particular court filing from 2023. We overlooked, and I apologize, the defendant's July 24th 2022 initial alibi response, which, as the court can see, essentially wasn't a response at all other than we'll come up with an alibi at some point. And then page 2, item number 7, it should be February 29th instead of February 23rd for the date. And I apologize to the court again for those oversights, and they're certainly entirely my fault. This issue has been argued back and forth in court since 2023, as the court can tell from the numerous filings that have gone back and forth up in Latah County that brings us to today. The state filed in accordance with the applicable rule and statute 19-519, and Court Rule 12.1, a discovery request with an alibi demand that requires the defendant to specify the place or places that he claims to have been at the time of the alleged offense, and then identify witnesses who the defendant intends to rely on to establish that alibi. The state's position is that to this date, the defendant has yet to do that. The best that we have is the defendant was out driving around. Well, we knew the defendant was out driving around. We have other evidence that show the defendant was out driving around. His phone was turned off, so we can't trace his exact location at the time of the offenses, but it overlaps and coincides with the time of the murders. The can's been kicked down the road several times on this, and it's nobody's fault. Judge afforded the defendant multiple opportunities to provide a compliant alibi response. That never occurred. The defendant's response from earlier this year doesn't have anything new or different. It talks about partial corroboration of a partial alibi, which frankly, the statute doesn't talk about partial anything, nor can we find that in the case law. The defendant acknowledges that their cell phone expert, Mr. Ray, can't account for the time of the homicides itself. Of course, we know that because the defendant's phone was turned off. So the only person who can testify to an alibi, if there is an alibi, is the defendant himself. If he elects to testify, that's fine. And the state's position is that he's allowed to testify, but under the statute and the rule for alibi notifications, there should be an order from the court prohibiting evidence from any other witnesses as to the defendant's location at the time of these offenses. The defendant retains his right to testify to that if he elects to do that. But nobody else should be asked to testify about specific places where the defendant has been, because we can't respond to that at this point, and to our knowledge, there's nobody else who can say the defendant was at a specific other place.
What about their expert, cell phone expert, who, as I understand it, will testify as to where he was or wasn't?
I don't believe that that's what his expert can say. The best their expert can say is that before the defendant's phone was turned off, the defendant's phone was south and potentially west of Pullman. But that was a significant time or a notable time before the homicides themselves occurred here in Moscow. There's nothing in the cell phone data that shows where the defendant was at the time of the homicides.
You don't disagree about the right to put on that evidence?
No, that's fine. I mean, that's an issue, the battle between the cell phone experts on the activity of the defendant's cell phone and what direction it was, but that doesn't apply to the time when the homicides occurred.
You're just looking to ensure that there's no witness who's going to appear who says, oh yeah, he was at my house at 4:06.
Yes, sir. Thank you.
Mr. Kohberger has consistently maintained his innocence and said that he was out driving in the early morning hours of November 13th, 2022.
And he can testify to that.
I'm going to get to that. We provided Mr. Ray as a partial corroboration of Mr. Kohberger's alibi in an abundance of caution. The thing I didn't want was to be here with Mr. Thompson saying they should have told us they had a partial corroboration, now they can't use it. So that's why we disclosed Mr. Ray as early as we possibly could. Mr. Ray took the stand in a motion hearing last May, I believe, and the state chose not to cross-examine him. I disagree that Mr. Judge gave us repeated opportunities to produce more. There was a mix-up about what an order meant when speedy trial was waived and the trial was reset and all of the deadlines were extended. That was the thing that happened there. So it wasn't repeated times that we had an opportunity to say more. But I will say this. This has been brought up repeatedly by Mr. Thompson. His pleadings with the court, his briefing, have a lot of reference to Mr. Kohberger having the ability to testify. In the few minutes he spoke just now, I counted 5 times he made reference to that. Our view is that's getting dangerously close to commenting on his right to remain silent. And I would cite the court, the closest case we could find was State versus Haggard. That's at 94 Idaho 249.
I think the issue is who's going to say he was out driving around looking at the stars?
Well, Your Honor, I think that's going to be a trial issue, and I think that if that's commented on trial, that's a comment on his right to remain silent.
The question is whether they can comment on it. The question is whether you have a witness who's going to testify to that he was at a particular place between the hours of 2:57 and whenever his phone came back on in 4:48. 4:48. If so, you have an obligation to produce that. If not, and your testimony, your presentation is that this is what was going on, you have to have somebody that's going to put that into evidence. You can't testify to that.
I'm certainly not planning to testify to that. I'm responding to requests for alibi, and a lot of times in cases, there is not going to be a response because a person's alone. The court's aware of that. But when you have what I considered a partial corroboration, that had to be put out there so that I could make sure I could call Mr. Ray to the stand.
I don't think they're contesting that, as far as I can tell.
That's what I heard them say today as well. I'm explaining why we put that out there. I would say that the state is continually asking a question that is a problem that hasn't arisen at this time yet. The only fear that I have, because of their repeated questions, is that there is something somewhere in the 68 terabytes of discovery that I haven't come across yet. If that's the case, I'd ask the court, if they know of it, I'd ask the court to order them to tell me about that. I can let the court know I haven't read every document in 68 terabytes. I haven't watched every minute of video in 68 terabytes of discovery. We have answered the question now. We've answered the question before, and this continues to come up. I would point out, though, that Idaho Code 19-513, subsection 3, that says if we learn of an additional witness that was not previously known, we can disclose that and the state can challenge that at a later time. I don't have that person now, but if I continue to review discovery that the state produced to me and I find something, then I'll bring it up. But I don't have that now. What I have is partial corroboration, and that's what I intend to produce. I also intend to cross-examine the state's expert about that if he's allowed to testify. That's it.
Your Honor, the notion of partial corroboration of alibi is concerning because that kind of begs the question between complying with the alibi disclosure statute or not. And
well, why shouldn't we just look at this in terms of the defendant's version is that Mr. Ray, in his expert work, is going to testify the defendant was at a certain place at a certain time, which is up to 2:50, whatever it was. As of this point, they have provided no other alibi witness.
Yes, sir.
Or the alibi instruction likely is not going to be given.
Yes, sir.
If they come across evidence that supports an alibi, is their obligation to immediately make you and the court aware of it? And then we'll deal with the issue of whether it is the timeliness of it and how we deal with it.
Thank you, Your Honor. The court articulated it much better than I could. That's exactly what we were looking for. Thank you.
Right. All right, let's talk about the AT&T stuff.
Thank you, Judge. This should be fairly simple. The state's seeking an order prohibiting the defense from continuing to allege that the state received timing advance records from AT&T for Mr. Kohberger's
When you
phone.
say continuing to allege, I'm assuming you mean in front of a jury.
Yes, what we don't want, throughout the entirety of this case, they've alleged that. We're seeking to prohibit them from making that same allegation in front of a jury because it's false. Timing advance records, really timing is what's at issue. And in 2022, the days that we're concerned about are 7 days. The event that we wanted records for was obviously November 13th. So in 2022, we had 7 days from November 13th to get AT&T timing advance records for anyone's phone. We did do search warrants for other people's phones. We did a tower dump, and we did a search warrant for 3 individuals. Those were all done on November 16th within that 7-day period, so the state did receive some timing advance records. However, by the time that Mr. Kohberger was identified in December 19th, and by the time we applied for a search warrant for his AT&T records, we were outside of that 7-day window, so there were no timing advance records to be received, and we did not receive any. The state has submitted an affidavit from Stephen Gordon, the AT&T Director of Compliance, essentially stating that we sought timing advance records, but they were not included because more than 7 days elapsed since November 13th, 2022, and the date of the search warrant, December 23rd, 2022. And the state just submits these affidavits should be dispositive of this issue.
Defense filed a document yesterday, and I don't have all the attachments, but it talks about a timing advance that was produced by AT&T in last April, I think.
Yes, so for that, it's still in reference to these search warrants that were initially asked for in November 16th of 2022. We did a part 1, and then later we did a part 2. But because we put in that request within the first 3 days, obviously a preservation request was also put in. So those records were obtained. So again, we're talking.
You're indicating that there were records obtained as part of your prior notification of need for AT&T to preserve those records.
Right. I have nothing further. Thank you.
Your Honor, we're requesting the court deny the state's motion and allow us to cross-examine their expert, Nicholas Balance, with regard to timing advance records.
What evidence do you have that timing advance records existed that the state could have acquired for Mr. Kohberger?
Well, Your Honor, specific.
I've read your affidavit of Mr. Ray, and he seems to entirely ignore the 7-day issue and doesn't address it.
Your Honor, his affidavit, I think, starts before to explain to the court some of the history about where the timing advance records come from. When Mr. Kohberger was identified, I'm going to jump ahead and tell you why I think I should get to ask Nick Balance about these records. When Mr. Kohberger came to the attention of the state and they began doing search warrants for Mr. Kohberger's records on December 23rd, there were 2 separate search warrants for Mr. Kohberger's AT&T records, and they requested timing advance records. And one of the pages that we gave you was the carrier request that said, give us 7 days worth of timing advance records. There were 7 days back, at least 7 days back at that time. Those have never been produced to us. What I've learned in working with Mr. Ray is that obtaining timing advance records now goes through a different process than it went before. FBI agents had a means to get these timing advance records before they were generally available to all of law enforcement. Generally available now comes through the GLDC program, and that happened in 2023.
But he's not indicated he has any evidence that, at least for this time of the murder, that those would still be in existence.
We've never heard from Nick Balance, who is FBI and who has the back door.
From AT&T.
You've heard from AT&T that GLDC did not produce these records in 2022. You've absolutely heard that from AT&T. What you haven't heard is the other way that...
The other way. I haven't heard that either. I've heard a general description, and I've heard in the affidavit that he received some once, and they said, oh, no, don't use those. I don't know if those were acquired within the 7 days. He doesn't address the 7 days. And that's a glaring, particularly given the inflammatory language in that accusations in that affidavit, it's a glaring omission.
Your Honor, we don't even have the 7 days worth, which is what the carrier request says. That
The 7 days that he's back home?
maybe.
I'll ask the state about those, if they receive those. I'm not sure their search warrant covered that time frame, but.
Your Honor, I would say that it did, and I would say their first search warrant was just a 48-hour period. It asked for timing advance records, but then the second warrant,
You would agree there's no evidence that AT&T provided those, or that those were still available by the time that Mr. Kohberger was identified?
Your Honor,
An officer of the court.
as an officer of the court, I would like to ask Nick Balance that, and here's why. Here's why. The things that I've learned is that the 7 days is on paper. Sometimes they go back further than other days.
What's the evidence of that, counsel?
The evidence has been in the practice that I've learned from people that I've worked with.
You're giving me that testimony now?
I'm not giving you testimony. I'm answering the court's question.
Okay. But you've made some serious accusations against the state of hiding evidence, and yet you've provided no factual basis, zero, that that evidence existed for them to be able to obtain it in December.
Your Honor, in April of, or I'm sorry, it was probably by the July date that I got it, of 2024, I got records from 2022. In some other time in 2024, I think it was May, I got 3,800 people's timing advance records.
Because they were asked within 7 days of the date that they sought it. It was the tower dump from the night of the murder asked within the 7 days.
I understand that.
Okay. So where is the evidence that Mr. Kohberger's timing advance records from AT&T were available to anybody in December without a prior request that they save those?
Well, I don't know if they made a prior request that they save those.
Well, they wouldn't, because they didn't know who he was.
You're correct. They didn't know who he was until, I think, about December 19th.
Correct.
Their warrant for his full scope of records, the second AT&T warrant, asked for all of the records. I haven't seen any of them. That's, even if they were just the 7 days back, I haven't seen any of
What
them.
you're talking about now is a discovery issue of those 7 days that don't sound like they're particularly relevant to the murder. That's a discovery issue you can take up with the court through a motion to compel, which you have not filed. It's not an evidentiary issue in which you can lay down Mr. Ray's conspiracy theory without any evidence at trial.
Your Honor, we have litigated this issue quite extensively throughout the course of the case. The timing advance records, once I understood how timing advance works, became very important. We've heard different things now than I've heard at different times in the past about this, particularly about the 7 days. That's newer information to me now. but the carrier request forms tell me I should at least have that. I want the court to know that we have had motions to compel on this very issue. We have had different bits of information.
For the 7 days that are after December, in December?
No, Your Honor, because the 7 days is something that's newer and has been brought to my attention
Our
more
motions
recently.
compelled related to timing advance records for November 13.
Our discovery requests were for all of Mr. Kohberger's timing advance records. Our motions to compel covered all of them too. I have this carrier request now that says 7 days, and I have the affidavit now that says 7 days. Those are not things that I always knew when we were litigating this issue.
Okay.
Those are new bits of information. To me, it is a little bit problematic that there's been things that have changed and there might be records out there. Given what you have now with the affidavit with 7 days, if you imagine you didn't know that and you...
I understand your confusion and concern previously. What I don't understand it is now. In light of the evidence, I don't understand Mr. Ray's accusations without addressing the 7 days that he had that information when he submitted his affidavit.
He is available to testify if the court wishes for him to.
It's his obligation and your obligation to establish that evidence of that the state has this, and you haven't done that. His affidavit is quite extensive, and he seems to ignore that issue.
Your Honor, I believe that that issue is touched on with his knowledge that these kinds of records existed a long time before.
He said that in a very general way about that without reference to the 7 days, and he had supposedly received them from some FBI expert to look at for his company, and then was told not to use them. So I don't know, maybe the FBI got them in a way that they weren't supposed to at that time, for all I know. He didn't name names, he didn't identify it, he didn't put it into any context. The state had indicated and provided AT&T's sworn testimony that they only keep them for 7 days. And yet he makes the accusations that he did in his affidavit without addressing that 7-day issue at all. And so I guess my point is if you want to cross-examine the witnesses about why didn't they rely on the AT&T timing information, you've got to show some factual foundation that that was available to them by the time Mr. Kohberger was on their radar as it relates to November 13. And I'm not seeing that as the problem.
My first question to Special Agent Balance, who would be the person who would have gotten these through a different channel, through the FBI, would have been, did you get them? Because I've heard different things along the case, asking him the question is really what I wanted to be able to do, and that's why I opposed this motion and prepared it as I did.
Tell you what, I'll let you ask that question outside the presence of the jury.
Thank you.
At the time of trial.
That will satisfy me. Thank you.
I'm not upset, but I just for Mr. Ray's information, because he wasn't here the first day I started this trial with you folks. I said, I don't want theatrics. I don't want accusations that aren't supported with evidence about supposed bad conduct of the parties. You're all professionals. I respect you all. And the accusations he made in there are very concerning. The kinds of accusations, if true, that would get people disbarred. And so without any evidence and apparently sidestepping the clear explanation, he makes those. And so that doesn't make me happy.
And to address the court's concerns of what's been raised, I think the only issue out there, I have the 2 search warrants. The state asked for the AT&T timing advance records in our search warrants. The state wanted that information from Mr. Kohberger. We did not receive it. I did not receive those records from AT&T. I do not have them. Thank you, Your Honor.
All right. There's not been a showing that those records were available And I think it would be unfairly prejudicial to try to impeach the testimony of the agent that somehow he hid or didn't provide or didn't use records that he didn't have available to him. So absent some factual showing that he had them available, I'm not going to allow questions about that, and I'm not going to allow testimony about that. Now, if you want to voir dire him before he testifies in front of the jury, I'll allow that. And if you show a factual basis for it, I'll allow it. But you haven't at this point.
I appreciate the opportunity to ask the question outside the presence of the jury. Thank you.
Thank you. All right. The vague and undisclosed expert testimony, I think in part touches on this, but not entirely. So I'll let you talk about the other entirely part.
Yes, thank you, Judge. Then you'll get a break from me in a few minutes, I think.
I enjoy dialoguing with you, counsel. I appreciate it.
Well, good. I think we're going to have some time together over the next 6 months or so. Your Honor, this motion came after our hearing in January, and we're asking the court to limit what the state can produce with their experts here. I do have copies for the court, extra copies for the court. We had a specific request at the end of our motion. We called it Exhibit 1, and it went through all of the state's experts and basically described what we think the court should do with the state's experts, and so I wanted to provide that to the court.
I did see that and read it.
Okay, good. Thank you. Let me get to my same page. I want to start, though, today with my presentation and my request with a little bit of history with this case, and as the other motions are, this motion, our motion for the court to exclude all of the state's experts as outlined in our exhibit is based in Mr. Kohberger's rights to a fair trial, effective assistance of counsel, due process, and guaranteed by discovery rules and rules of evidence and the court's own scheduling order.
It's rooted in Rule 16, which is kind of where the court looks at these issues.
Rule 16 it is, yes, Your Honor. This started with discovery requests very early on where we asked for expert information from the state. I'll skip forward to the court's scheduling order, which was very clear about what should happen and that we needed to have our expert disclosures in at a certain time. The state's date was December the 18th, and shortly after we received the state's expert disclosures, we filed a motion to compel. We wanted the rest of their disclosures. We had a dialogue in January about that, and the court asked me, why are you doing this? I'm going to make them abide by the rules, by the discovery rules. I really thought when we filed that motion, the state would say, oh, okay, and we'll just get you the information. Most of these are experts they've been working with all along. But that's not what the state chose to do. The state chose to say, nope, I'm going to dig in my heels, and we did plenty until the court said your job is not done.
Well, to be fair, and in the way I handle these issues with Rule 16 in the criminal context, the rule is not particularly broad about what is required. And the court has interpreted that rule fairly narrowly in other cases. I give the speech that I gave to you both in most cases where there are a lot of experts to encourage sharing beyond that which is required, because I think it helps both sides. And I think it helps the experts be better prepared to testify because counsel understands their testimony better. I think it allows for cross-examination better. And I think it creates just a more fulsome picture of things that way. And that's why I invited the state to supplement. And I also invited you to be likewise broad in your disclosures. Now, at the end of the day, I am bound by Rule 16, and so that is my guidepost.
Well, Your Honor, I believe Rule 16 references the Idaho Rules of Evidence, and I believe that the state's requirement is to provide at least the opinion that their expert is going to offer. And case law, it's the State versus Marin case, says that bare lists aren't good enough in this case. Your Honor, the state didn't immediately file and fix the issues that they had, but we filed our disclosures, and our disclosures weren't bare bones. They were exhaustive in method and analysis and opinion. And the state gained an advantage when it happened that way. The state then went from having their experts due on December 18th and really setting the bar. We have the burden of proof. This is what we're going to do. These are our experts, and this is how we're going to do it. They went from that place with their duty and their obligation to giving minimal, which were just lists other than a couple of their experts, and then receiving all of ours. And you can see in the next bit of pleadings that really shaped what they were going to do. When their rebuttals came due, they got an extension until February 17th, but that didn't see them fixing the problem that they had in large part. Some reports came in March 3rd, some March 14th. So the state has effectively given themselves months of additional time and the advantage of having our expert reports. And that just can't be when you're looking at fairness of trial, when you're looking at who has the burden of proof, when you're looking at due process. The state is to say, this is what we have, this is how we're going to prove this case, and for us to decide how to respond to that. And that got turned upside down with what the state has done here. They held back, gave us bare lists in large part, and then had the advantage of having all of our work, how we would anticipate we might rebut the state's evidence, and allowed them the advantage of deciding what to give us and when. It is extremely difficult when the state gives things just a piece at a time to us. It is extremely difficult when we have a deadline and we have plans, we have our experts, we have our schedules with our experts so that we can continue to prepare as we head towards trial. To have the state act in this fashion, to hold back and then to give things little bits later without even giving a full expert analysis in some cases. The court has the duty to ensure that we have a fair trial and that Mr. Kohberger's due process rights are adhered to. And the court should exercise its discretion and apply the rules and limit what the state is able to produce as far as their experts. I'm going to talk a little bit about the different experts here. They are outlined in Exhibit 1. I don't think I have to go through every single one. We tried to be pretty clear for the court if the court looks at that when considering our motion. But I do want to talk about a couple of them. And obviously, Agent Balance is the one I'm going to want to talk about. Your Honor has heard some things about this disclosure. I can't call it a report because it's a PowerPoint. I don't know what Agent Balance's conclusions are. And Agent Balance doesn't, the PowerPoint obviously isn't going to be complete. PowerPoints aren't designed to be complete reports of what happened and what somebody thinks has happened. We've had several different disclosures now. They don't help much. On March 3rd, for the last time, we learned that Agent Balance acknowledges he analyzed the last 7 minutes of data on the phone, but we don't know what his opinion is about any of that.
Allowed to give an opinion about those last 7 minutes?
I'm sorry?
Doesn't that just mean he's not going to be allowed to give an opinion about those last 7 minutes? I mean, I can't force his expert to have an opinion, their expert to have an opinion.
You can't, and we're here asking you to limit what they can testify to by surprise once we get to jury trial. Agent Balance is worth further comment to the court. Agent Balance was co-located with investigators in this case from the very early days, just a couple of days after the killings took place. He is somebody that the prosecutors have had meetings with and have had ready access to throughout the course of the proceeding. So it's not like he's a stranger that they couldn't get his report from him. He has offered his PowerPoint with no analysis of these phone transactions, no analysis of the mapping that was done, and to understand that he conducts drive testing and he carries around a scanner when he does his drive testing, and that scanner will collect data about which towers are working at that given time. So you can get a lot more accurate information about where a device might be. The other way to look at what devices are doing is when you're looking at different cell towers and the phone transfers from one to the other as the phone might move around in a car. But the drive test data working with that shows you a place where there's a tower, all the places that there might be coverage, and then if the phone hands to the next tower, it'll show you that coverage too. So you can see limits, you can see gaps in where coverage is, and that helps you identify where a phone is more. Agent Balance hasn't analyzed all of the data he collected, nor has he told us what it means. So for Agent Balance, the court should preclude his testimony about the last 7 minutes, and the court should preclude the rest of his testimony, really. I think the state's initial disclosure was that he was going to talk about cell towers and how they work with cell phones. That might be fine. Anything else, they shouldn't. I want to tell you, though, while we're on the topic of that last 7 minutes, that it's more problematic.
That was part of the initial disclosure, correct?
The PowerPoint, I believe, was provided as a disclosure.
Did he testify for the grand jury?
No. Officer Mowry, Detective Mowry testified before the grand jury. Agent Balance did not. So I don't have any of his testimony. But I want to tell you about the 7 minutes. And I want to tell you that those are problematic. When the phone's moving, when Bryan's phone's moving the last 7 minutes before it goes off the network, and you look at the locations of where the phone was, it places the phone in a place at 2:54.45 in the morning. And for Agent Balance to ignore that, there's a cascading impact on other bits of testimony that will come in. So it's imperative.
That's just impeachment.
Well, it's actually exculpatory to Mr. Kohberger, so it's worse than that. So
You're doing this in the frame of a motion related to the expert disclosure, and so his opinion is what his opinion is, and he's disclosed what he's disclosed. And let's just hypothetically say he can't opine about the last 7 minutes because he hasn't disclosed that. And I haven't gone through in enough detail to make that conclusion, right? Isn't that then just a matter of you putting on testimony from your expert about that 7 minutes and impeaching him about, you didn't even look at the last 7 minutes. You missed that. And what could that mean? Couldn't it mean, as my expert, obviously your expert won't have testified by then, but impeach him essentially on his lack of diligence, as you would put it.
Well, I anticipate impeaching for the lack of diligence. Here's the fear, though. I don't know what he's going to say about those 7 minutes, so I want to impeach him about that. I want to impeach him about a whole lot more, too. But if I do, and he says, well, I did analyze it, actually, I hope the court's order stands and he's not allowed to talk about it.
You have to be careful about what doors you open, but
I agree, and when the court said that, it made me think of that. Going back to what I'm asking you to exclude, I'm asking you to exclude everything that wasn't contained, and there's no opinion, there's no analysis contained in that original PowerPoint. There's just PowerPoints with a few things on them that he won't be able to explain because
they did supplement and explain, at least in some detail, more about what each slide kind of means, as I understand it.
Well, Your Honor, that comes back to kind of where we started with the state waiting to see what we had. That's not how this works. In the adversarial system where the prosecution has the burden of proof, we can sit at the defense table and do nothing. I don't have to produce a thing. they have the burden always to prove the case. And what they've done is they've turned that upside down. They've essentially and figuratively shifted the burden by holding on to what they had, even though they have the duty, and said, show us yours first, and then we'll rebut your experts. And that's just not the way it works. And I think the court should look at their disclosure deadline, and they didn't go home from the January 23rd and 24th hearing when the court said, your job's not done, I'm not going to allow things in that aren't disclosed. They didn't go home and say, we got to get this done now. They trickled things in, bits at a time. And that is just not the way the system works, and that's in violation of Mr. Kohberger's rights, and we're asking the court to limit it. What they gave us on December 18th, that's what they get to talk about. There was no opinion in there, no real analysis in there. And that's our position, and that's the way to bring it back and keep the burden at the table it should be and protect the due process rights and the right to a fair trial at the table it should be. In our filing, I won't read it all to you. We had a lot to say about that with agent balance.
Search warrant application include the analysis of the cell teller information?
Did the search warrant application include the analysis? Let me think what the search warrant application said first.
That large, omnibus document that they used,
Oh, Exhibit 1 that was attached to all of them.
attributed to, if not the signatory, but the FBI CAS team.
Well, we're talking about a couple of different parts of the affidavit. There was the factual part of the affidavit that Moscow Police Department, various members of the police agency used it, the same affidavit or a couple different versions of that same affidavit. There was a part that I don't think Nick Balance ever signed it. I think he dictated it.
Were you on notice of what the state's version through the CAS team of what that data showed?
If I look at the affidavits, there are a few things, yes, that I would be on notice for. They're not attributed to Nick Balance, but there are a few things. Those are the problem areas, and I don't want to open doors that I shouldn't. I mean, I either need his analysis if I'm going to open the door, or he doesn't get to talk about it. And let me tell you what I mean.
Talk about the adversarial part. I also look then in that case at what information you did have about what the state's case was. And so, it seemed to me that in general that cell analysis was part of that, because part of the motion on your part was the missing 7 minutes.
That definitely was part of the motion, and now for the first time I know he actually analyzed it. What that affidavit, those two affidavits, I would tell you about 3 parts that could be attributed to any cell analysis, and then I'm going to tell you the problems with those 3 parts too. The first is that the phone went off at 2:47 a.m., which it did not. It did not. That's untrue. The other is that the phone was traveling towards Moscow when it went off, and that's absolutely untrue as well.
I recall the 47 said it was traveling southwest.
Well, that's what we say. That's what the record shows.
That's what the application said.
The application said that the phone stopped reporting to the network at 2:47 a.m.
Traveling southwest at the time, southwest of Pullman.
That's not when the phone stopped reporting.
I realize that, but
Okay.
It's not like they were representing that it was at 2:47, halfway to Moscow or traveling to Moscow. It said it was southwest of Pullman, which, as I understand, the 2:52, 54,
70.
7 minutes later indicates that it was traveling southwest of Pullman.
None of the search warrant affidavits have anything about 2:54. It was.
I understand that. My point is, the time was wrong, but the point, the direction of travel is the same.
There are paragraphs in the affidavit that talk about the phone traveling towards Moscow. There are slides in Agent Balance's PowerPoint that have an arrow, and that's not true.
Well, there is a, in the search warrant affidavit, I think as part of the PowerPoints, I don't remember the language it used, but basically the believed route of travel or something like that. In other words, their opinion of what the travel route was. And so that was disclosed, what that alleged travel route was.
Cell phone records would indicate something different than they said. So I see what the court's doing. The court's saying, okay, you have this PowerPoint. What else were you on notice of? I'm on notice of things that the records contradict, the records being the AT&T records that we received from the state. And those records contradict those things in the affidavit. I'm also on notice.
Allow for supplementation of expert disclosures to correct errors, to provide new information, to make them fuller. I mean, the rules allow for that.
That's not what they've done.
I understand that's what you're saying, that's what they haven't done.
That's not what they've done, Your Honor. And
That's why I'm looking at what did they actually say beforehand, because I think part of it is a notice issue to you.
well, I'm on notice of things that the records don't support. I'm on notice of a PowerPoint that doesn't have any analysis or opinion in it. So those are the things that I'm on notice for with regard to Agent Balance testifying. So I'd ask the court to not allow him to testify beyond the December 18th very limited disclosure. We have the disclosures that still have some vague language in them, and we talked about this back in January, where it's imperative to not let people offer opinions based on this vague language that they can change their opinions. That happened a lot with lab people. There were some additional disclosures with lab people bringing in CODIS. That came in the
That's not an opinion, first of all. It is an explanation of why they didn't submit evidence to CODIS. I'm not saying that it's an opinion. That's just a statement of what the facts are.
Your Honor,
It's not expert testimony. That's, here's our policy, here's when we submit stuff to CODIS, and here's when we don't. And this has been raised as an issue. Why didn't this get sent to CODIS? And this is why. I don't see that as an expert disclosure issue. That's purely a factual issue.
So the protocol allows the individual, a certain analyst, to make that decision. That's what the protocol says. The why of that decision has been something that we learned about for the first time in the February 17th disclosure. That was curious.
My point is I don't really view that as expert testimony. That is simply the underlying factual happenings. It's like, why did you then make a phone call to this person? Well, because. I mean, it doesn't make it an expert opinion. In my expert opinion, I thought it'd be good to call this person. These were fact people on the ground making decisions about the investigation. Now, in today's world, and as the state pointed out, there's an over-disclosure of fact witnesses as potential experts so that they're not caught in the situation the lawyer was with the drug recognition expert with the state police when it was determined, well, he was offering an expert opinion about something in that regard. And so you get a lot of fact people disclosed in expert disclosures, but I'm not sure how, because there was a lot of briefing back and forth on that, how the decision whether or not to send the stair rail DNA to CODIS is an expert testimony. It's just basically lab protocols.
I think as long as it doesn't tread into an expert opinion about that, we can.
What would that be?
I don't know. I haven't read one. I don't know. I mean, if they're having some opinion about what those spots on the handrail and the wall look like, I guess.
Well, I mean, I wouldn't expect to see at this point an opinion that, it was the DNA of Y person. Right. Unless there's been newly discovered evidence.
Well, I don't have any of that today, but I understand there's more for me to pick up, but I don't know what it relates to. With regard to the lab personnel, I think the best thing to do is keep them to their lab reports and the disclosures that are explanation but not opinion. The concern that the defense has with a lot of the lab personnel is some of the loose language about the ability to testify about other things. And as long as they're kept to those opinions, I think we're informed on most of those. Again, not going through everyone. I do want to annually ask Dawson, though. Dawson was an expert that was disclosed in rebuttal, but there was nothing to rebut. He's an expert that talks about toxicology. And we are.
Didn't you produce an expert who said that that there wasn't it would have required two people to commit the crime?
Your Honor, we have produced an expert that believes that it's likely that there were two people, two weapons. That
Dawson
doesn't.
testimony about the degree of intoxication goes to the what I'm assuming was, given that degree of intoxication, the ability to fight back. In rebuttal to your experts, as I understand it.
I think that's what the state says. I don't think that's proper rebuttal. Well, because we didn't talk about intoxication, because the state's medical examiner talks about defensive wounds anyway, so this would seem to be contradictory with other testimony that they intend to put on. We are not contesting the intoxication level of any of the deceased.
I understand your argument.
Thank you. Again, Your Honor, I think that our exhibit stands on its own, and I just wanted to highlight a few of these. I do want to talk about the cell phone and third-party data, digital data disclosures. We have a little bit more in the way of opinion now, but not full opinion. And the state said that we didn't give them enough to rebut, and that's because we don't know what opinions their experts are going to come up with. They still haven't disclosed full opinions, and so we want to highlight that for the court.
What haven't they disclosed?
Well, in the Barnharts, they said they were going to talk about habit evidence. I don't know what that is. Most of the rest, there were three, Mowry, Urig, and Tanzola, that looked at the digital data and the cell phone data. I don't have any idea what they're going to talk about, except Urig is going to say that there's no connection between Mr. Kohberger and the others. That's the only actual opinion that's been disclosed. And that the last one I wanted to highlight for the court is the Douglas, Special Agent Douglas's testimony. That seems to have shifted a bit from he's going to talk about bank records and debit purchases, and it's become bigger without any opinion. I don't know what his opinion about anything will be. That needs to be limited. I think he can come in and talk
through the financial records and say, this shows a transaction with Mr. Kohberger's credit card to purchase a Amazon gift card, and that this Amazon gift card was used to purchase a knife.
If he can say all of those things, I think that his ability to talk about receiving the bank record and looking at it and saw a purchase history, I think that's fine. But to provide an opinion about what that means, that's not disclosed. Well, Your Honor, I don't want to wait to find out. I'm asking the court to.
My point is I'm not in a position to exclude their testimony because they haven't shown me that they're offering something beyond what they've disclosed.
Your Honor, I respectfully believe that the court is in a position to limit what hasn't been disclosed and would ask the court to do so. The state has had a lot of time to provide these disclosures to us, And what they've done is taken the advantage of having our disclosures and bit by bit giving them to us. This is challenging to prepare a case of this magnitude in any event, and to have things piecemealed out just delays our preparation time. And it's also in violation of the discovery rules, it's in violation of the court's order, and it violates Mr. Kohberger's rights to a fair trial, effective assistance of counsel, and due process. And it is within the court's realm to say, you're not going to do any more after this particular date. There's no opinion written down for certain people. It can't be offered now, and we think that's what the court should do. If we wait until we take it as it comes during trial, that's better than nothing, but it's very difficult to prepare, and it eats into what limited time we have to prepare, and it will waste a lot of jury time to have to take these things up again and again and again. The state knew what their duties were. They've done this for a long time, and they chose this course of action, and the court should limit what they can do and issue an order limiting their experts. That was for me. Yeah. Okay.
Defendant makes a lot of assumptions about what has occurred. However, I can tell you the state didn't wait to see what the defendant was going to disclose first. That would be an incredibly risky game for us to play. And that's not what happened. We know what happened. As laid out in the state's response, the state filed our initial disclosures on December 18th, 2024, disclosing 25 experts for the guilt phase. And then at our last hearing on January 23rd, the court addressed this issue. And Your Honor stated and issued a word of caution, instructing the parties that the disclosure should cover over-disclose. We should really go back to our experts, lay out, and you talked about the amount of work that this would take well in advance of trial to go through everything that they intend to testify to and put that into a disclosure. And that it doesn't go as far as the civil rules, but that you didn't want to have these issues coming up at trial. You were very clear in that you directed to the state that our work was not done. We took that to heart. You did not set a specific deadline, but instead instructed both the parties that supplements would be reasonably allowed. In response, we did immediately go back. We went back to all of our 25 experts and asked them to review their testimony. We had to have several meetings to discuss what their testimony was going to be, and they supplemented their disclosures. On March 3rd and March 14th, the state filed the supplemental expert disclosures. I submit to you that the state has complied with Rule 16. We have a continuing duty to supplement. The defendant has filed expert disclosures past their deadline. The state has allowed that. We are trying to be reasonable in this. And in fact, in that stipulation to allow them more time to disclose, we stated, it serves the interest of the parties and the court for there to be reasonable flexibility to facilitate the development and exchange of relevant information to assist the trial jury. That's where we're at, and that's what we're asking for. Thank you.
If we were talking about one expert of the state's, that might make sense. We're talking about wholesale not complying with Rule 16 and with the rules of evidence regarding experts. When we realized that the state hadn't complied with the rule and provided us very little in the way of understanding how their experts would frame the issues in the case, we sought an extension to prevent the state from having our work first so that we could try to respond to what their expert disclosures were with our experts. That wasn't something that was given to us. That was denied, so we filed our expert reports. For us to have a couple of experts that came later when the state has done their job as they've done their job, that is really a hollow way to say they did it so we can too. The state did not comply with Rule 16 or with the court's order, and the court should limit what they're allowed to produce at trial.
All right, I'll take that matter under advisement. I did invite the parties to supplement. It takes time to supplement. I'll look through to see if there's any significant new additions. Well, first, I'll look to see if what is given is adequate, if there are concerns. Secondly, if there's anything that was provided that wasn't shaping and as I've said, making more fulsome, making more whole, making more clear what opinions there are. The defense I know was given, and as I explained, the defense has the ability to supplement as well in response to the state's supplementation. Part of the reason the discovery order is as early as it is to the trial date in this case is because in my experience in cases of this, we have this problem always of ongoing, continual supplementation and disclosure, and so I wanted to accommodate that within the time frame, within the several weeks to months in advance of trial. And so I'll look at it and I'll get you an opinion. All right. Amazon click activity.
Judge, this issue really ties into what we've just been discussing and I think is illustrative of the problem. So when motions in limine were due, we had notified the court that we didn't have expert disclosures on opinions on Shane Cox, who was going to be their Amazon expert, and Michael Douglas, who they had listed also as having information about Amazon. So when we raised the issue with the court about incomplete disclosures, like Ms. Taylor was talking about, we still didn't have those at the time that it was time to file a motion in limine. So our motions in limine. So the motion in limine related to Amazon Click and Amazon Records has to do with a lack of disclosure. When we filed the motion in limine on Amazon Records, we then got supplemental disclosures on Shane Cox and Agent Douglas, but not with any opinions.
Are they expert opinions or witnesses, or are they just fact witnesses to say, here's what the Amazon records show?
Well, I'm going to explain why it falls under expert opinion and what we've come to learn in trying to figure out what this data is. And I'll
there
talk.
May be some rebuttal stuff in there based on your disclosures in terms of why the Amazon data, as I understand it, you're saying shouldn't be relied upon or admissible because AI made me do it.
Well, I think it's a broader explanation than that. But the issue is that we had received this data and without expert opinions to explain what the state intended to do with it, it left us in a spot of trying to figure that out.
How was it vague what they were trying to do with the Amazon records? It was pretty facially evident what the relevance of those
They're not facially evident, Judge. We have an Excel file that has a ton of names with metadata, and then we have what is known as an Amazon click packet that the state has produced, we think from Shane Cox, that has a sheet that talks about specific purchases that include the knife, include things like the gift card that you were just talking about. but without any context. And our hope was that with expert disclosures, we would understand, was there going to be testimony from them that somehow there was information on computer searches specifically from computer examination, or the context of what metadata might explain about the ClickPay documents that they got. We now have some information because we have got an Amazon expert who has explained to us what we have and what we are missing. Obviously, the evidence is important to the state's case related to the Amazon information. And given the court's direction about its intention for us to call experts today, which Mr. Howell is available, we went ahead and submitted a declaration when the court said that you were disinclined to allow testimony, and we sought leave, but we didn't get a solid answer. So you've now got an affidavit in front of you, declaration.
Typically in motions in limine, I'm not being in a position to make factual credibility findings and the like, and so the testimony on paper is more than adequate to guide the court.
Okay, I appreciate that. So I'm going to explain then what the basis is for where we're at. The other issue that of course the court knows is that we sought to seek suppression of the Amazon records because the warrants were extremely broad. We expected to be getting significant data or have data that we hadn't yet reviewed. The court denied that suppression issue. And so what we know that we have now is the list that I explained, but it's without metadata. And so for the purposes of what we've got going on here, there is, pursuant to Rule 106, a whole level of context that's really important to the Amazon data. And it's not just AI technology, it has to do with machine learning. And I think a lot of this is something that
AI.
Pardon?
Isn't that AI, machine learning?
I think that machine learning, I'm definitely not an expert on this, Judge, but I've provided you with a declaration. And if you want me to put Mr. Howell on to testify about
That's
the
not
difference
important.
between, he's far more articulate at it than I am. It's a combination of both with what happens with Amazon. Because in terms of machine learning, one component is that when there's a household account where there's multiple users with multiple cell phones and multiple laptops going into purchases, there's machine learning and cross references there. In terms of the way that Amazon works as a company globally and artificial intelligence, they're doing all kinds of things to understand what consumers and purchasers and sellers are trying to do to actually prompt people to buy certain things. So in this instance, with regard to these purchases, we have very limited data regarding Mr. Kohberger's purchases without the metadata and the context. And that's the reason that we are seeking to exclude it. Now,
Well, you got
Pardon?
what they got, right?
not really, because what we have is we know that they're going to draw conclusions and that they're going to draw conclusions about intent, but the way that they've presented it to us in data is that this relates to Amazon clicks. Well, Amazon clicks makes it sound like to me and you, someone goes on and actually, with a mouse, clicks, opens a document, takes it into a cart, purchase it, and it's a much broader term than that.
And the state's testimony from their person who will testify that this is what the Amazon data shows is that Amazon data shows that Mr. Kohberger, or at least his name, purchased the knife sheath and cleaning thing, knife sharpening, equipment, and looked as anybody who orders on Amazon does. Is it Where's it at in delivery? And then later on that same account, after the homicides, looked at knives again. Now, I understand the defense's position and evidence and expert to be that, well, that's a shared account and anybody could have done that on that shared account. I don't know that that's a matter of exclusion, though. Isn't that a matter of just impeachment and cross-examination and your own experts?
That if the court doesn't exclude it, then that would be the remedy and the approach that we would take.
Would it ever be the remedy of exclusion?
Judge, if you don't exclude it, then that would be the alternative, I
What
guess.
basis would I have to exclude it?
I started with that we did not have expert opinions at the time when we had to file a motion in limine regarding this data. And it's misleading that the way that you just portray it, that because there is a purchase in a household account, that is automatically attributable to him, and then and that there's somehow
Not a purchase in a household account. It's attributable under his particular name in the account, as I understand it. Now, could somebody else in the family get to it? I don't know. I suppose your expert will tell us that. But I'm not sure how that is excluded, and I'm not sure how that's expert testimony. I understand you have an expert to say, well, you know, all these other factors come into play and all these other things could have happened, and okay, you can put that on, but I'm not sure why that excludes the state's evidence.
Well, it would be extremely misleading given the declaration that we've put before the court about everything that goes into the way that Amazon
You're
functions.
asking me to be the fact finder again. I mean,
I'm not asking you to be the fact finder. I'm telling you that when we don't have complete disclosures and we're playing a guessing game of what this information means, and we have deadlines where we have to file motions, then we end up in this circular situation right now, right? Because we had to file a motion about this without knowing what the opinions are and what we're lacking in data. Now I have an expert who's explaining it. We've asked you to exclude it. You're indicating you don't think it's an expert opinion. And so then the next logical step would be our expert comes in and we're allowed to confront the evidence. But you also just proffered that, you know, that based on the information that you understand, that equates to a purchase. And I've put a declaration in front of you from an expert that says that Amazon doesn't work exactly that way. And that's the problem, that when it is represented as a click, that indicates to the average person that he sat at a desk and clicked and made a purchase when there's a lot more to that.
and maybe I'm completely out to lunch, but as I understand it, to buy something on Amazon, you got to put it in your shopping cart and hit purchase. Am I wrong about that?
No, that is a step, but how it gets in your cart and what items get in your cart really has to do with the whole model and the ecosystem of the way that Amazon works, right? And so the state wants to apply in an argument, they will apply intent to purchase a K-bar to get to November 13th, 2022.
From the evidence to argue at closing arguments.
But we still have to have testimony that explains those things in between.
Welcome to put on testimony that implies that Mr. Kohberger was not the one that hit purchase, or that he purchased it for a benign event, or that here's the knife, I have it. I don't know.
And based on what you're saying, that the Mr. Cox you think is a lay witness, then I'm assuming that also extends to him not being able to testify beyond what the disclosure is as a lay witness and no other opinions, and including Agent Douglas, who's given us no opinions whatsoever.
I don't know what they're going to say beyond that. And if they say something beyond that is an expert opinion that hasn't been disclosed, then the state's going to have a problem with it.
Okay. That's why we're having these arguments, Judge. They take a lot of work. It takes a lot of energy. It keeps us from 68 terabytes of evidence. Well, if everybody would just disclose, we wouldn't be having this back and forth.
The problem is you view it as a more complex issue than the state does.
Because it is.
Well, that's not their worldview. okay? And that's the factual dispute that the jury gets to decide.
So what we're trying to do is make sure that their myopic worldview is what they're held to, because there is a much bigger picture to this evidence. Okay.
Judge, this is pretty simple. Shane Cox and Mike Douglas, since he gets brought up, they're fact witnesses. They're not going to have opinions. They review records. They're going to testify to what those records show. Shane Cox's testimony is laid out in the supplemental amended disclosure. This is exactly what he's going to testify to. And what he's going to say, he's very careful in what he says that he's going to say. That's what we're anticipating. There is no grounds to exclude his testimony. We applied for and we were granted a search warrant for Bryan Kohberger's Amazon.com user activity. The search warrant was narrow in scope to items related to the homicide and evidence related to the seizing of knives. In this case, it was knives and knife accessories. It directed law enforcement to see certain items: his customer click activity pertaining to knives and accessories, his payment methods used, details of items in cart, including all items added to the cart or removed from the cart or wish listed or in a shopping basket, all suggestions made to the account, all records regarding reviews by other Amazon users, advertising data, devices used to connect to the account, and all accounts linked to the account. The state requested the data between limited time periods, March 20th to March 30th, and November 1st to December 6th. Those were the relevant time periods. And in response, we got responsive data, and that's what we plan on presenting to the jury. Amazon's use of AI is not a basis to exclude, and it's completely irrelevant. AI doesn't click on things for a user. There are no legal grounds to exclude this. We ask that you deny their motion. Thank you.
Thank you. So I think there's a fundamental, just different worldview as to the relevance and impact of the Amazon data. And the defense is entitled to challenge the data in terms of, does it really show who bought it? What else did they buy? In what circumstances? I understand the state's not really going down that apart from what the data shows, which is the purchases that have been laid out in the report. If the state tries to go beyond that without having disclosed those or without a rebuttal disclosure to some of the things the defense has disclosed on that, then they're not going to be allowed to testify to it. But there's not a ground for exclusion because you have an expert that thinks that the evidence can be explained in a different way. That's just simply a fact determination for the jury based upon the conflicting evidence. All right, let's take 10 minutes and then we'll see if we can't bring this home.
That's the latest from the courtroom where Bryan Kohberger sits and motions hearings playing out. Sure to press subscribe so you don't miss anything on this case and the many that we cover for you right here from True Crime Today and the Hidden Killers podcast. I'm Tony Bruschi. Stay with us.
This has been a special report from True Crime Today and the Hidden Killers podcast.